Good morning, guys.
Everybody good?
Yep. Hey, I'm assuming you folks have some questions.
Gentlemen, on Wednesday you said these are just allegations. Your client hasn't done anything wrong, and you don't have to explain anything that's happened here. If that's the case, if she hasn't done anything, why not explain? You don't have to, but why not explain?
Because we don't have to. Because the way this works, the state has to prove those allegations. They're just allegations on paper. They're just, there's no need for us to do that. As much as everyone doesn't like the idea, there is still a presumption of innocence. And that presumption of innocence has been eroded out here, and I'm trying to protect it in there. I know everyone wants to crucify her, everyone's already convicted her, but that's not how this works, and it's not how it's going to work. And the burden is not going to shift to the defense. The burden rests on the state. They got to prove these allegations in court, and we're a long way from that. And I recognize that that's an unpopular sentiment, but that's what it is.
What is that was referenced in court by the judge?
There's nothing that we care to expand upon. That's really nothing of significance.
What do you have to say about the new witness who claims that Kimberly didn't acknowledge her stepson, didn't even mention his stepson? Over 20 years
Is some random witness that wants to come forward and make these allegations. It means nothing. There's going to be plenty of people that are going to come out of the woodwork and have all these horrible things to say about my client. We'll see what's actually admissible in court and what stands up in court under cross-examination.
Can you talk about setting the Draconis statute, which deals with these conditions that happen pre-trial? Why was that important to mention that today?
What I was referencing a case. There was a decision in the Draconis case, and in that case, the judge, there was some case law there where it tied in the right to bail and the presumption of innocence. In the written documents we filed 2 memorandums objecting to what the state and what the court did today, what the state sought to do and what the court allowed them to do. And in the memorandum, we do detail my client's rights and how they could be violated and harmed by the decisions that are being made. And one of the arguments we made is if the court was to impose these sanctions, which we believe were not justified, that it could impact my client's right to a fair trial and bear upon the presumption of innocence. I'd be more than happy to share our pleadings with you. The cases are detailed there. We think we made very strong arguments. We think we made appropriate arguments, and we'll consider whether we will appeal any decisions that are made.
Last question.
Will you be able to get a fair trial? You know, I know in other cases they've tried to move to other jurisdictions, feeling like the current jurisdiction that they're in, they can't have it. Do you feel like that's something impossible?
I feel like I might be one of the few people that's really fighting to make sure she has a fair trial. It is crucially important that she has a fair trial. It is crucially important that we protect the presumption of innocence. It is crucially important that we not rush to judgment. And, you know, the popular sentiment is to convict her. But what people need to understand is if we're willing to trample on Kimberly Sullivan's rights, but then other people's rights are also going to be trampled on. Our constitutional rights need to be protected in that courtroom. And that is what we intend to do, and we intend to defend her and represent her to the best of our abilities. And despite the public sentiment, despite the rush to judgment, we're not going to sit for that. We're going to do everything we can to defend this woman. She is presumed innocent, and in the eyes of the law, she is innocent unless until, if ever, a jury determines otherwise. Thank you very much. Have a great day, everybody.